Okay, so in the last class we had been talking about copyright, and we had just moved on to the question of what can be protected by copyright. And as we saw, there was a huge variety of things. We looked at the text from the Berne Convention that defined what literary and artistic works was, and we saw that that was a very broad selection of things. Over time, technology has developed and new things have come along that we feel are worthy of protection. And for the most part, what we've done is we've made the definition of literary works so broad that things fit in under that. So that's the approach that's been taken, stretching the definition of literary works beyond, say, books and works of literature to pretty much quite a lot of stuff. These were two quotes we saw from two cases that dealt with that, and a sort of shopping list of possible things that can be protected. So we're going to look now today at what can be protected and what are the criteria applied to something to see if it's worthy of protection. This is the text of the law in Ireland. So there are international treaties such as the Berne Convention. There are a whole bunch of directives from the EU that would require member states to implement certain laws. We might look at the details of some of those where appropriate. But all of those then get distilled down and get implemented as national legislation. So since we're in Ireland, we're going to look at the Irish Acts. In the UK law would apply. And in France, the French law would apply, and so on. From time to time, there'll be something interesting somewhere else, so we might have a look at that. But since we're in Ireland, it's the Irish law applies here. And so if you do something in Ireland, the permissibility of that will depend on Irish law, because you're doing it in Ireland. Now, it does, of course, get complicated if you do something in Ireland and you upload it to YouTube, like where does it live, which law applies. That's a whole other area then, and that does come up. So, in Ireland anyway, the Copyright and Related Acts 2000 specifies that copyright subsists in original literary, dramatical, musical or artistic works. So that's a selection there. And then sound recordings, films, broadcasts or cable programs. So it wasn't possible to fit sound recordings into literary works. That was stretching it a bit, so we put them in there separately. The typographical arrangement of published editions. I was talking a little bit about that the last day, I'll mention that again. And then original databases. And we'll look at that too. So this is section 17.2 of the Act. Now, there is this principle that the law doesn't concern itself with trivial things. Just fix that there. Hate typos. And some things are just too short or too trivial to be considered works worthy of protection by copyright. So names and trademarks and titles of things typically can't be protected. So that's a problem, because it can mean, for example, that someone can produce another book with the same title as your book, and there might not be a whole lot you can do about that. There's quite a few books on Amazon. Amazon has this kind of marketplace where you can write an ebook and people can download it to their Kindles, and they can sell them for a couple of dollars or whatever. It's a way to promote to give new authors access to a marketplace. But there are quite a lot of books that one could argue are posing as other books. And when you download them having paid, you realize it wasn't what you thought it was at all. But you can't copyright the title of a book, typically. There was a case involving the title of a TV show called Opportunity Knocks, which was hugely popular in the UK. And some people in New Zealand were using that, and there was a case, and it was held that Opportunity Knocks was too short, too trivial to be worthy of protection. There was a case involving Kojak, Hitachi as well. There was a slogan, an advertising slogan, "Beauty is a social necessity, not a luxury." Someone had a similar advertising slogan, and there was a case there, and it was held that that was too short to be copyrightable. There was a song, The Man Who Broke the Bank at Monte Carlo, and then someone made a movie with the same title, and there was a dispute there, and the court held that that was too short to be worthy of protection, or too trivial. Okay, so there is a minimum threshold in terms of length, anyway, somewhere there. Of course, drawing the exact line is tricky. Computer programs posed a huge problem because many people argued that computer programs aren't really literary works. They're just instructions to a computer how to do something, and that there's very little of the author in there. There's very little discretion. And so how you protect computer programs was a big question. As a programmer myself, I would never have agreed with that point of view anyway, but I could see why people would think that. Now we put computer programs in with literary works. So we've squared that circle by deciding that computer programs are literary works, so therefore they're protected. Also, the work that's done in preparation for writing code, so all the analysis and design work, that's also protected. Because you could see how most of the work in writing a program would be the analysis and design, and the actual coding is only a part of that. Without protection for that, it would have been open to someone to come along, basically rob all that and implement it then themselves using their own code, having done the bulk of the work. A typographical arrangement. We mentioned this the last day. So even separate from the copyright in a work, the typographical layout of it might also be worthy of separate protection. So J.K. Rowling obviously owns the copyright in a Harry Potter novel, but the way the Harry Potter novel has been laid out on the page, if that's sufficiently original and worthy, may be separately worthy of copyright protection. So that becomes an issue, or becomes more obvious, if there's a work that's out of copyright. So most of the works of Arthur Conan Doyle are out of copyright in most of the world now. There was a bit of a twist in the US there, but so if you could take a book that's out of copyright, you might produce a gorgeous edition of that. You may have gone to great lengths to produce a particularly attractive layout. Or you might have taken a text file of the document and gone to great efforts to code that as an attractive ebook or PDF or EPUB or something. And you might get cross then if someone came along and just took that and started selling it also. And so the typographical arrangement can in itself attract copyright. And in Ireland, that's in section 29 of the Act. and that copyright can expire then. That copyright can be had, and it would expire then 50 years after the date it was made public. So you could take a book that's out of copyright, produce a gorgeous ebook of it, and you might have copyright in the typographical arrangement. Someone else could go away and make their own ebook using the same source, but they can't just rob yours. Now, how much you would have to do in order for it to attract protection is a separate question, but in principle it's protectable. Databases then posed a huge problem, and databases are not considered literary works, and they're dealt with separately, and we'll look at those later in a separate class. So databases are protectable in Europe to a much greater extent than they are in the US. That's a source of some friction, actually. But we'll look at databases thoroughly in another class. So, copyright subsists. That's a very important point. And what that means is that you don't have to do anything special to copyright a work. So you recall this was one of the things countries signed up for when they signed up to the Berne Convention. There was no registration process for copyrighted works. There was nothing in particular required in order to copyright something. So a work might be protected by copyright as soon as it's fixed in tangible form, but it does have to be fixed. So if it's fixed in tangible form and it's original, then it's protected by copyright. So let's look at the first of those conditions there, the one to be fixed in tangible form. So if you write something down, it's in a tangible form. If it's not written down, you have a problem. So if you have a great idea in your head for a novel, well, that's not protected. If you recite a poem in public and nobody writes it down, it's probably not protected. Now, if somebody does write it down, then it is in tangible form. And it doesn't even have to be you that wrote it down. Someone in the audience could write it down. You still have the copyright in it, but they wrote it down. But at least it's in tangible form then. Why do you think that might be? How practical is it to protect ideas in people's heads? If you have an idea for a book and someone else has the same idea for a book and they write the book,
you might have an idea, but
you haven't really done much about it, like, do you know? I mean, I happen to think ideas are to a penny. I have loads of ideas, I'm lazy, you know? And this goes back to the justification. First of all, it's not very practical to protect ideas in people's heads because, you know, who's to say they have them or don't have them? You know, I actually thought of Harry Potter first, and that won in England, you know, like, I mean, don't get me started on her. It was my idea. But like, how can a legal system work with that, with ideas in people's heads? But also if we go back to the justification, where you have the instrumental justification for copyright where it's to provide benefits to society, and then we have the author's rights justification where the creations of people's minds are their own and they should have control over them. Like, how useful to society is an unimplemented idea in someone's mind? Well, it's feck all use, like. If you have a great idea and you fall under a bus tomorrow, well, it wasn't worth a whole lot to us. So why would we protect that? Now, if you're coming from the author's rights point of view, you might want to start protecting things like that. But from an instrumentalist benefits to society point of view, ideas in people's heads that aren't acted on aren't worth diddly squat to the rest of us. So we want to incentivize people doing something with their ideas. So it must be fixed in some tangible form. So although that's a requirement, the law is very flexible as to the form. So the way in which you fix it can, we can deal with various ways of doing that. There was a case a long time ago in the US involving piano rolls. Do you know what they are? At the start of Westworld, and it always starts with the piano roll playing music. So it's like a roll of paper, almost like about the size of a kitchen roll, and there was holes in it, and it was the notes to be played on the piano. And there was a case a long time ago involving piano rolls, and the argument was, well, a human can't read the music off a piano roll, so it's not fixed intent. That's not a proper fixing of it. But so when we see the way the legislation is written now, it can be fixed in a tangible form that can be read by humans or with the aid of some device. So this means that if you record something on a tape recorder or you record something on a hard disk, it does count as being in tangible form. Now, a hard disk isn't a lot of use without the computer to read it, but for the purposes of the law, that counts. So the law is quite flexible in terms of the form, even if that form is the charge or the magnetic field of a piece of plastic or on a piece of metal on a hard disk being changed from a 1 to a 0. It would be interesting actually if something was stored only in RAM that would only work as long as there was power there. I'd be curious to know if that was tangible or not. You could maybe devise a case where,
sure, like data in RAM can be used in court cases. So couldn't it be said it could be used?
Well, is it tangible? I mean, you could probably devise some very bizarre borderline case where it's there, but not there for long enough to be tangible or fixed. But yeah.
As long as it resides in RAM, it does exist. So.
But is it tangible? Is it fixed? That's it. We could, argue that. But it's more like that's kind of, we get into almost a philosophical question at that stage. So as a general rule, the law anyway is pretty flexible about the tangibility, the form of that. So it has to be tangible. That's non-negotiable. If it's not fixed, it's a deal breaker. But the form in which it's fixed there's flexibility there. Okay, so that's the first thing. But that's really, really important because some people have ideas, share them with other people who act on those ideas, and then they get cross. But like an idea you don't act on, an idea you don't fix in tangible form isn't protected. So what some people do is before they enter discussions with someone, they agree that the other person can't use the idea or can't act on it. And there's the law of confidence, where you tell someone something in confidence and then they have to respect that. And so that comes up in intellectual property law as well. But you have to be careful. Your idea is not protected until it's fixed in tangible form. So once J.K. Rowling wrote her book, that was fine. It was protected. But before it was written, she had nothing. Just an idea. And the law doesn't protect ideas in your head because, well, you know, that's not worth a lot to the rest of us. Mostly. Now, the next criteria then for protection is that it must be original. So the work must be original. And there has been a lot of discussion over the past 300 years as to what constitutes original. As a general rule, the threshold for originality is very low. So the courts will protect works even if the amount of originality is fairly minor. For the most part, originality means little more than not copied from someone else. So when we talk about something being original, we said that was a really original story or original movie. We are using a very, very high threshold of originality when we say that. In copyright law, the threshold of originality is like way down there. Okay? And we already mentioned in the last class that the law has no interest in something being any good or not. The law doesn't want to act as an arbiter of quality. And so there's this labor, skill, or judgment test. So in the English-speaking world, if you want to know if something is copyrightable, first question is it fixed in tangible form? And the second question is, how much labor, skill, or judgment was involved in its production? And that's kind of the test. Labor, skill, or judgment. So you see, we're focusing there on effort and investment, not creative genius spark or anything like that. So there was a case in 1964 where the judge said that original means only that the work should not be copied but should originate with the author. Damn you, autocorrect. So that's a fairly low threshold of originality. Well, you didn't copy it from someone else. But that's pretty much where copyright in the English-speaking world is at. As recently as 1964, anyway. So labor, skill, or judgment. And as a general rule, you don't need a whole lot of that. And all of the emphasis is on the investment by the author. So how much effort went into producing that work? And this has its roots then in the instrumentalist justification for copyright. So we want people to invest effort in works so that society can have more of them. We need to incentivize that investment. So it's very much a business transaction type proposition. Can anybody see any problems with the labor, skill, and judgment, or using effort as a measure of whether something is copyrightable or not? I mean, I could labor over a drawing for a week, and Picasso could, throw something down on a napkin while he's waiting for his espresso to be made. And there's a very good chance that the thing he threw together would be way better than mine, because his level of skill was so good that no amount of labor on my part was going to really make up the gap. So the amount of effort that's put into something isn't really a good measure of how good it is. But at the same time, the law isn't interested in how good it is. You know, Picasso's drawing and my drawing are both equally worthy of protection. Now, the benefits that might come to me from mine are probably much smaller than would come to someone by his. But in terms of meeting the criteria to be protected, there's no great difference. But certainly measuring effort and labour is perhaps problematic. There's some variants of the test. So in 1923, the judge talked about knowledge, labour, judgment, or literary skill or taste. That was in Macmillan v. Cooper. In 1964, the judge talked about work or skill or expense. So again, we're talking about the investment that was expended in creating the work more than the finished product. And in British Leyland Motor v. Armstrong Patents, they're talking about skill and labour. That was in 1986. So someone invests in producing a work, the law is inclined to protect it so that they can recoup that investment. So it's very much a business type thing. Now there's a very significant case from 1900 which drives this point home, because the degree of originality that was involved in the case could not have been smaller, in my opinion. This is as unoriginal as you can get, I think. So there was this chap, a politician, Lord Rosebery, who was, it seems, quite the orator, and a reporter transcribed some of his speeches. And these speeches were published in the Times newspaper. Then in 1899, a book of his speeches was published, and it used text copied from the Times. So some of the text that was in the book was copied straight out of the newspaper. And Lord Rosebery himself was making no claim to the copyright. He had no issue himself. He wasn't a bit concerned. But the newspaper and the reporter, who was Walter, argued that he had the copyright in the speeches because of the effort that he had put into in transcribing the speeches. Now this is back in the day when a reporter would have had to have shorthand skills. Do you know what shorthand is? It's a special thing reporters used to be able to do, and secretaries, where you have this special way of writing that can be written really, really fast as people speak, so you don't miss anything. And I guess the reporter would also have had to put in the punctuation, the commas and the full stops and things like that. And the House of Lords ruled that there was copyright in the speeches because of the effort required to transcribe them. So you could see this is very much protecting the reporter's investment in his time. And even though all he was doing was transcribing someone else's speech. So that's, to me, I think, is as unoriginal as you could get, but it was effort. I mean, it would be interesting today if a reporter gave a speech and you turned up with your microphone and just recorded it and then wrote down what he said. Apart from the fact that the speaker had the copyright in his words, I wonder would a court be prepared to accept that there was a whole lot of labour, skill or judgment involved in completing the same task in 2017. It seems to me to be a whole lot easier today. You could probably even get software that would convert the speech for you, and you just have to have a quick look over it and change the odd thing. But certainly anyway in 1900, I think we could all probably accept that there was certainly a bit of work involved in that. And the House of Lords ruled that that work made the end result protected by copyright. So here are some of the things that were said in the House of Lords. It is a great hardship if protection is not given to reports of speeches which can only be produced by the expenditure of much time, money and toil. Expenditure, time, money, toil. Effort here is what's being protected. We would very much regret the conclusion that the state of the law permitted one man to make a profit and to appropriate to himself the labour, skill and capital of another. So again, someone else's effort, and it's morally wrong to derive profit from someone else's effort. In my opinion, the reporter is the author of his own report. It was he who brought into existence in the form of writing, and here we have his memory and trained judgment. So again, his effort was what brought it into existence, and so that's investment that's being protected. So the law is interested in protecting that effort, that work. How trivial then can you go with that? So there was an interesting case, Interlego v Tyco Industries, and this was in 1988. And it was a bit complicated because there was some technicality about how a particular law applied in Hong Kong or something at the time. So it was a bit of a technicality, but the case hinged on whether redrawings of technical drawings were themselves protected by copyright. So for some reason, the existing blueprints, they were produced before some cutoff date that applied in this case. And it was being claimed that these had been redrawn after the cutoff point, and that these redrawn technical drawings were protected by copyright. It involved clones of Lego bricks. So the Interlego there, the Lego in Interlego is the Lego we know and love. And it involved kind of generic Lego bricks, and Lego was claiming that the copyright in the technical drawings for the bricks had been infringed, even though no copying had taken place. But for them to win the case, they had to demonstrate, for some technical reason that's not really important, that the redrawn blueprints, the redrawn ones that had been drawn after this particular date, were subject to a separate copyright. And that didn't fly. So it was ruled that the skill, labour and judgment merely in the process of copying cannot confer originality. So if we have a drawing here, that was drawn 20 years ago, if I redraw it, the new one doesn't have a whole new copyright. Okay? Because it was just a slavish copy of an existing work. So even though there is a lot of effort involved in redrawing a technical drawing, I mean, we could all attest to that. It is time consuming, there's effort, there's labor, even skill, even judgment required. By redrawing an existing drawing, you don't get a new copyright in the new thing. Now, you could argue that that's exactly or largely what happened in Walter v. Lane, but also you could argue that in the almost 100 years, or actually almost 100 to the day, that I guess the technology had maybe advanced that making copies was so much easier, or that transcribing a speech would be more difficult, would be easier now. It was more difficult back then. So a copy of a work doesn't get a new copyright. And so this leaves us with the question then, well, what do you have to inject into labor, skill and judgment? What do you have to add to that effort in order to get a new thing? But of course, copies of existing works, is a bit troublesome anyway. So photographs then are, of course, another tricky one. If you have a photograph of something, is there a new copyright in the photograph? And this was a tricky one. So, much like Colin the programmer thought there was actually a lot of effort involved in writing code and a lot of discretion and a lot of authorship in there, Colin the photographer would also argue that photography is not a trivial thing. It requires a lot of labor, skill and judgment, and often some significant investment. So if you go off to Vietnam and take some interesting pictures, I mean, you had to pay for the flights, to pay for your hotel there. You also had the time and effort and labor, skill and judgment required to take the pictures. And so I think we would all agree that when you come back with those pictures, other people can't just use them and not pay you, that you have ownership of those. But what happens if you take a picture of an existing work? Or if you take a picture of something, like, is there a scenario in which it's so trivial that you don't get protection? So there was a case, antiquesportfolio.com versus Rodney Fitch and Co. And the argument there was that the antiques were old, so they weren't subject to copyright in their own right. And the question was, well, does a plain vanilla photograph of an antique have copyright in it? And the court ruled that a three-dimensional object could be the photograph of a three-dimensional object could be original work because there was skill and judgment involved in positioning the object and choosing the correct angle. So if you take a photograph of a three-dimensional object, that's a new work. But two-dimensional then was trickier. So like if I take a photograph of the Mona Lisa, we could all agree that Leonardo da Vinci once had the copyright to the Mona Lisa, but he is like way dead now. And so does someone who takes a photograph of the Mona Lisa own the copyright in that picture? And that's a harder one because, okay, there is certainly some labor, skill and judgment and effort and potentially even investment in producing that photograph. But at the same time, all you're trying to do is produce a perfect copy of the original. And if you're trying to make a perfect copy, well, how original is that then? Like, how can that be original? And so the jury is kind of out on what happens if you take a photograph of a two-dimensional object that's intended to be a perfect replica. And this has come up in a dispute with Wikipedia and a gallery in the UK, because the portraits of people who were painted 200-300 years ago, there's no copyright in the actual paintings anymore. And the gallery is claiming that it has the copyright in the photos of the paintings. But Wikipedia is saying, well, no, it's just a photo of a painting. There's nothing in there. There's no authorship in there. There's nothing in there that makes it worthy of a new copyright. And can anybody see a problem with the argument that a copy of a two-dimensional work, a photograph of a two-dimensional work, is itself protected by copyright?
I can see it in certain circumstances, like if I went over to the library and didn't want to pay to photocopy some books and photograph them instead.
Yeah, but if there was no copyright left in the book.
There's no copyright left in the book.
So if there's no copyright left in the book, if the author of the book is long dead, so the book itself has no copyright in it, and you take a photograph of the pages, and then someone uses your photographs, can you say, hey, no, I have a separate copyright in the photographs of the thing that doesn't have copyright in it?
I would imagine that I'd have the copyright having taken the photograph. If somebody's reusing my photograph.
Yeah, but then, so suppose it turns out that I wasn't as lousy a painter as I thought I was, and I was giving Picasso a run for his money. I know, a bit of a stretch. And photographs of my paintings were being sold by my family to make some money. And then 70 years after my death, my grandson comes along and takes a new picture of my paintings and then says to the people who wanted to publish books of my work, no, you can't do that now, because I took a picture last week of the painting, so now you can't publish that book until 70 years after I'm dead. Like if photographs of work themselves get a whole new copyright for another 50 or 70 years or whatever it is, then when is the copyright on a two-dimensional work ever going to expire, really? If you can just take a new picture every time. So if the painting that's hanging in the National Portrait Gallery from 300 years ago can be subject to a new copyright, kind of, every time someone takes a picture of it, is that not really the same as it never going out of copyright? So this raises an interesting question. So far anyway, two-dimensional objects, the jury's out. But a photograph of a three-dimensional object is a new work, even if it's just a slam bam eBay type, here's the object photograph. Like, we're all quite clear that photography is an art form, and creative photography creates photographs that are worthy of copyright protection. But mechanical, straightforward, here's a picture for eBay, but they're protected too. Okay? But photography messed things up a bit. We had a concept of copyright that was for protecting books and a concept of originality. And then photography as a whole new technology did rock the boat a little bit. Now, so labour, skill and judgment is the main test in the English-speaking world. On the continent then, there's this idea of the author's own intellectual creation, or this is the English translation of that continental concept. And this comes from the author's rights tradition, where the creation of an author is protected as an extension of his or her personality and an extension of his or her rights as a human being. And if we look at the French intellectual property code, it talks about oeuvre de l'esprit. So you can see that's capturing more of their humanness, their creative spark. And I won't attempt that pronunciation there. But this is from the German copyright law. And so this is more about the personality, the creations of the mind, the creations of their intellect. And there's a directive protecting photographs from 2006. And it says, a photographic work within the meaning of the Berne Convention is to be considered original if it is the author's own intellectual creation, reflecting his personality, and no other criteria, such as merit or purpose, being taken into account. So if it's the author's own intellectual creation, reflecting his personality, then it's worthy of protection. And there's no other test. There's a directive from 2009 on computer programs. And it says a computer program shall be protected if it is original in the sense that it is the author's own intellectual creation. So again, an intellectual creation. And no other test needs to be applied. And another directive on databases. Again, the author's own intellectual creation, and no other criteria shall be applied to determine their eligibility for that protection. So the only test is it the author's own intellectual creation? Now that seems to me to be a higher standard. Like if we go back to Walter v. Lane, I mean, would you argue that the transcript of the politician's speech was the author's own intellectual creation, like the reporter's own intellectual creation? That seems to me to be a higher threshold than labour, skill or judgment. And this raises the question, is this a new test being applied? Do these directives require courts in Ireland and the UK to apply this higher threshold for copyright protection? So some people are worried that this is a shift away from labour, skill and judgment, which is the English instrumentalist test, to the continental creations of the mind, author's rights test. But maybe not. If you think about it, like photographs, computer programs and databases, they were always the problem children anyway, weren't they? So maybe this is just saying, do you know what? Look, labour, skill and judgment was never going to work for these boyos anyway. So here's a different test for those. Because it is interesting that this language has been used only in these more unusual cases. And they are, I think, special cases, things that we want to protect, but that originality might have been hard to demonstrate otherwise. So where that test was never going to work, here's the new test. So maybe it's still okay, although there are certainly people who think that once the UK leaves the EU, Ireland will be kind of on its own in some of these areas. Now, the next thing I'm going to talk about, but not right away, I'm going to take a break, I think. It's a good time for a break, and this is a good natural pause, is the idea-expression dichotomy. So we'll take a little break, and we'll come back.